All right, everyone. I want to thank you all for coming out today to this program and webinar. Thank everyone who's in the room today, as well as those people who are attending remotely via the webinar, to the program of what entrepreneurs and investors should know about alternatives to bankruptcy. My name is Robert Mallard. I'm a partner in Dorsey's Wilmington, Delaware office, and I regularly represent clients throughout many stages of the pre-bankruptcy planning, Chapter 11 reorganizations, Chapter 7s, as well as other kind of, insolvency advice to clients who are considering alternatives that are maybe not in the bankruptcy court. I also act as Delaware counsel in other litigation matters in other various Delaware state and federal courts. I'm going to take a moment to introduce the panel. We have next to me Kevin Mailer, who is a partner in Dorsey & Whitney's Minneapolis office. Among his other practice areas, Kevin's a member of Dorsey's Emerging Companies and Technology Commerce Group. He also works closely with clients to understand their business objectives, to structure transactions and meet those goals. He regularly advises clients in drafting, negotiating complex commercial agreements, IP property licenses, distribution agreements, supply agreements, and joint ventures. Next to Kevin is David Johnson, who is a partner at Sherwood Partners, Inc. David has had 17 years of experience in financial advisory and business restructuring roles, including operational improvement, cash management, creditor negotiation, and litigation resolution. During his tenure at Sherwood, David has advised investors, lenders, and management for over 125 companies. He is also a CFA charter holder. And next to David is Tom Wong, who is an associate in Dorsey & Whitney's Palo Alto office in the heart of Silicon Valley. He's a member of Dorsey's Financial and Restructuring Practice Group. He also represents debtors, creditors, lenders, and fiduciaries, among other things, in Chapter 7 and Chapter 11 bankruptcies, informal reorganizations and workouts, corporate wind-downs, and general assignments. He also represents business litigation plaintiffs and defendants within and outside of the bankruptcy context. One note also before we begin, there should be some green pieces of paper on each of the tables. Please make sure you sign in, and that will help you make sure you get your CLE credit for attending today. Also, at the end of the program, at some point, we'll be emailing around a thank you with a survey about the program. Please take the time to fill out the survey. What we're going to be discussing today is a pretty 30,000-foot overview of these issues. If there are any of these topics that you would really like to go into more depth on, let us know, and depending on the reception and feedback, we may need to plan another program to go more into depth into one of these topics, so please look for that. So today's program is really, I think, focusing a lot on emerging companies and what happens to them when they struggle. And I first wanted to kind of get to Kevin and also David and Tom and just talk about, in this environment, what are emerging companies faced with in terms of their success rates?
Yeah, so from my perspective, and I work with a lot of emerging companies, I help them raise capital. I don't know that I can answer that perfectly, but what I hear from venture capitalists is out of a portfolio of 5 companies, it's their expectation that one's going to do extremely well, 3 are going to do okay, and one's not going to do well at all. That's often the company that's going to end up in the scenario that we're going to be discussing today.
Yeah, Sherwood Partners is based in Mountain View for a reason. We get a lot of our clients from venture-backed companies. The companies may have something valuable, intellectual property, patents, software, yet the company may not be able to survive as a going concern. So that community is got built-in failure.
Tom, any input on that and kind of what you see in the industry right now?
Nothing really to add aside from, we're talking about when venture funding has already come in. There's a lot of companies that, before they even get to that point, that are already struggling.
So first of all, we're going to really focus on what executives and board and companies should know as they get into kind of where they might be feeling distress and some of the warning signs, red flags they might see, and at those points, really what actions they should take. We'll next talk about, kind of once they've gotten to this point of, oh, now what do? What are some of their alternatives they can take that are maybe outside of the bankruptcy court? We've come up with a hypothetical, company D, D stands for distress, and I'll ask kind of Kevin and David to go through this scenario and kind of give us your input on how this scenario kind of maybe encompasses a broad spectrum of different situations emerging companies might find themselves in.
Sure, I'll walk us through our hypothetical company here. It's got a capital structure where it went out and raised about $1 million from angel investors who are owning common stock. And then as is common, they've raised some money from a VC and an institutional round that in our scenario raised $5 million, Series A preferred stock. This is hypothetically a company that has a technology platform. The business concept was that it got a wearable band that syncs with their platform, but the band would be sold through a big box retailer, so that's got excitement. That was a good story to tell to investors. Investors were excited. It has a consumer play to it. In our scenario, we've burned through a lot of that money. We've got $2 million left in the bank, and the board has learned some unfortunate news. So our scenario is our initial estimates for where we'd be right now for revenue is unfortunately wildly off. We are not making the revenue we thought we were. We've discovered that the technology platform is not as robust as we thought it would be. It's got security problems, and those are not easily resolved because to fix them, we'd have to shut down the platform, not really a good option here. The big box retailer itself, which was a big part of the investor story, is going through some problems that we didn't anticipate. They've got store closures. There was a champion within the big box retailer for our story, and that person has left. We had a great master services agreement with a big box retailer, but it had a termination for convenience clause that was something we couldn't negotiate out, and that agreement is now terminated. So a major change in our business plan. And we've had key employees who we hired after the Series A round closed, great people, but they're leaving, and the feedback we're hearing is that the CEO is mercurial, and this is all just coming to the board's attention. We've got a burn at $200,000 a month, which technically leaves 10 months of cash at the current staffing levels and with the current expenses, but that is a bit misleading, as we'll discuss. Any further thoughts on this company? Is this the kind of company that you would expect to see coming to you?
This is a typical scenario for a company that comes to us and maybe not with that much cash left in the bank. This actually is a good point to start planning your options, and you've got a little bit of time to do so.
So David, at this point, is there typically a secured creditor, or would a secured creditor maybe come later in the process? Or
in this scenario, there's no secured creditor here, but very often we do see a bank. A bank has come in conjunction with a venture lender, perhaps, and so a secured creditor is another dynamic here that we'll talk about.
So I think one of the first issues that a board might consider as they're finding themselves in this distressed situation is, what are a director's general fiduciary duties? Kevin, I know you advise companies on this all the time. I want to give a quick description of what the fiduciary duties are at this maybe before and at this point in time.
Sure. You have a duty of care as a director. So here, the duty itself doesn't change, but the facts have changed. So the board really needs to dig in here, start understanding what's happened, and what its various options are.
So Tom, as a company moves into a distressed position and becomes, insolvent, or they discover they're insolvent, does that change a director or the executive's fiduciary duties at all?
I think it doesn't really change the duty in so much as it changes the constituent to whom the duties are owed. The duty is really owed to the business enterprise, but now, when the company becomes insolvent, you need to start thinking about creditors being able to file derivative lawsuits against, on behalf of the company against directors, because they're now constituents of the company.
So does it, does the company's place of formation where they bring their lawsuit, does that change who can bring, when the company's insolvent, who can bring an action?
Yes, that's correct. So when they're insolvent, creditors now can bring a derivative action, whereas before it was only shareholders. One thing I might point out real quick regarding the business judgment rule is, we're talking about directors here, but officers in some states aren't protected by that rule.
That's a good point.
So it's a distinction that you might want to bear in mind depending on your state. They still have the fiduciary duties, however.
So David, as you, are brought into a company to advise them, does the board have questions to you about how they should be acting with respect, not legally with respect to fiduciary duties, but things that they should be doing?
Yeah, the board is going to want to know what its options are, what the cost of those options are, and what they should be doing, largely to protect the officers and directors. They know they've got a duty, they know they have responsibilities to make payroll and such, but often don't know which of several paths that they should choose and how to choose those paths. So we'll talk about some of those options later on, but the first thing that we want to tell them is speak with Insolvency Counsel to understand how your duties are changing now that you may be in the zone of insolvency.
So if you notice, we'll have two slides here, warning signs for mature companies, warning signs for emerging companies, and this to either any of you. Is there a difference between an emerging company and a more mature company in terms of the warning signs or what happens at these points?
Yeah, I'll take that. I think that the warning signs might be not that dissimilar between the two, but even the warning signs might be different. A mature company might not have a sudden loss. They might just be watching erosion that is just not going to stop. The mature company, in my experience, would be one that has revenue, has a business, and might be able to take some actions like monetizing assets that pushes off the problem, maybe gives you a little more time to solve the problem, whereas the emerging company generally has little to no revenue, entirely dependent on the funding of the investors, and it's often the investors' decision not to invest further that really precipitates the crisis.
So there's a lot of times loss of investor confidence that does it?
Yeah.
Okay. So going back to our hypothetical of company D, would you classify that as an emerging company or like a more mature company?
I think our scenario, we've got an emerging company with zero to very little revenue.
Okay. So, considering the hypothetical of company D as well as your own experience in advising clients, what are some of the more significant warning signs that especially emerging companies should be looking for? I don't know if Kevin want to take this or toss it to Tom or Dave.
Yeah, go ahead, Tom.
Well, we have a list of different warning signs for both emerging and mature companies, and they're really internalized within, they can fit within either scenario with this caveat of what Kevin has described. With the emerging company, a lot of it can be tied to a single event, such as Kevin said, the investor is losing confidence and not willing to put any more money in. If they're focused on developing a specific product and something falls through, they don't get regulatory approval or whatnot, that could really crater the company and serve as a warning sign. We have the 6 months of cash listed on our PowerPoint here, and that's really kind of unrealistic because that 6 months doesn't really take into account your wind down costs or whatever costs you need to expend for dealing with the situation. So 6 months is really unrealistic. And another thing about the 6 month marker is from the lender's perspective, this could also be a sign to them that something might be awry, that and they might be thinking at that point, do we put this over in the special assets or do we need to start looking at our collateral and make sure everything is perfected, et cetera?
Yeah, I would add too, I was thinking if in the scenario where there is a secured lender, these things you see on the list are going to be triggering covenants almost certainly. And if the bank's paying attention, which they don't always do, they're going to sit up and take notice and either start asking some tough questions, maybe even requiring that the company bring in someone from the outside to validate the business plan, or even spend more time with the company making sure that things are going in the right direction. If they don't, then it's certainly on the bank's radar, and they'll get ahead of it if the company won't.
So on this slide, one of the things that we have listed are ethical issues. So for either a mature company or an emerging company, how would an ethical issue be a warning sign? What type of ethical issues?
Well, you could have kickback issues, especially with a mature company, Foreign Corrupt Practices Act issues. All of these are both major crises for a company, but also potentially warning signs that there are deeper culture and institutional problems at the company.
Right, and you can also, you could just have a public perception that there's something unethical going on, and that could really hurt your business product as well.
So now we've identified a problem, the red flags are up. What should a company do next? Hey, Kevin, Dave, or Tom,
Yeah. Well, I'll take a first stab, but I'll let you talk more. I mean, I think this first bullet is really important. It's important for the CEO and the CFO to really dig into the financial performance of the company. We need to understand why we missed those revenue targets. We need to understand where our costs are, and not just the ongoing costs, but wind down costs. What would it cost to get out of this lease? What would it cost to separate from our employees? Which employees are critical going forward, and which do we have to consider separations simply to get through this time period? So that first one, I think, is a critical part of performing your fiduciary duties as a board member, and really pressing the officers, the management, to figure out what's going on there.
And in my world, it's all about cash. So the first thing that you do after you speak with Insolvency Counsel is want to make sure that you or an outside firm can get their arms around how much cash do you have, how much cash runway does that mean? Because it's all about cash. That's what provides optionality. And so when you take a look at the next points on the sheet here, can you reduce your burn rate? Can you raise additional funding? Those are key things. I have clients that can't afford to shut down because they've got to make the final payroll payments, they've got to make the vacation payments that have accrued, there's some other expenses. And so it's got to be all about cash. Forget GAAP accounting at that point. How long are we going to be able to keep the lights on? And that'll tell us what our optionality is.
Just a couple other points. We talk about looking beyond the balance sheet there, and Kevin alluded to this, but you want to look at what leases you have, what executory contracts and whatnot, and if you terminate those or you can't, or you breach them, what your what liabilities then come onto your balance sheet. And then you also want to look at what the situation is with your bank. Are they are you out of covenants with your bank? Can they sweep your accounts and so forth? Those are other considerations you want to.
Yeah. One last item on the last sheet too, looking at, from the board perspective, the management team that you have in place. At some point, you need to add, the board should be asking, is this the right management team for a wind down, if that is where it's going? It may not be the same skill set as the entrepreneur who has visions of a giant company.
So if they decide that maybe there's a change in management, what does that require from the board to then find the proper people to handle it?
Yeah, that's no small thing. To find a management team that's willing to step into a distress situation is not easy. There are professionals who do that, so you could maybe look at that. I would hope that the board has contacts and can start figuring that out. And it may well be that this management team is the right management team, but I think that evaluation is something the board needs to think about.
So going back to the hypothetical, it says that they have about 10 months of operating cash available. I mean, is that really enough, especially in terms of a company that might be looking to market itself? Is that enough time and money to do the marketing process, or should they be considering that earlier?
Well, if they really have $2 million in the bank and they think it's going to last them 10 months, you are where you are. But keep in mind that money's not going to last 10 months at a $200,000 a month burn rate, because you've got to map out your path. And if you're going to raise money, that's one thing. If you don't think you're going to be able to raise money, then you need to plan for what happens at the end of the runway. And that is, again, paying out these end of life things, accrued payroll, which builds up and is often a week or two in arrears. You've got accrued vacation. You may have severance contracts. You may have other tax issues such as sales tax. And then you've got to hire somebody, likely, to wind things down and monetize assets. These assets, if they're accounts receivable, they don't collect themselves. If they're inventory, they don't sell themselves. So you've got a budget for those large expenses at the end of the life, and so your $2 million isn't going to go as far as you think.
I know one of the questions I get when I've spoken with you, Kevin, and Dave, and other people who may have a client who is in one of these situations and they reach out to insolvency counsel is what sort of personal liability will a director or officer or other executives face, for the decisions they make during this distressed period? And I don't know if you want to talk about some of the big five, concerns that Ds and Os have with respect to personal liability for decisions they make.
Yeah, I mean, this is the big question that directors have, because they understand they have potential personal liability here. All of the items that you see there are things that can come up and catch you. The ones that seem most relevant and the easiest to violate is the first one, wages. And we see that a lot. You delay on making a decision. Keep hoping that we'll come out of this and start to see a turn upward, yet you still have wage obligations, and if you can't make that payroll, there can certainly be consequences.
In addition to the big five, there's another list of quite a few examples of sources for potential personal liability. I know, Dave, in one of your comments, and both Tom, you've mentioned that 10-month period, maybe $2 million of cash, is not really realistic because there's a lot of things you have to consider in that process. And I know there are situations, too, where you may get to the point where you're distressed and you have no cash. So when it comes to, the proverbial robbing Peter to pay Paul, if they have a choice between, they haven't paid employees for a couple weeks, they have, withholding taxes they have to pay, at that point, what does the company do?
Well, that's when I turn to the lawyers, Tom.
Well, I think you need to consider your business judgment and your fiduciary duties at that point, and weigh your options. Essentially, I mean, you might not have any good options. You might have, two options that one is just worse than the other. But you got to keep in mind that your duty is to the business enterprise, and notwithstanding this personal liability hanging out there, you need to bear in mind who your duty is to. This really just underscores what the importance is about getting in on this early, because you want to have enough cash where you have options to deal with some of this stuff. When you get to that point where you don't, then you're really left with not so many good options. One thing that you might want to bear in mind too is that just in this situation, you have an officer or a director who might know that the company is failing and can't meet its obligations, and you need to be wary at that point of what promises you're making, whether it's promises to employees that you're going to pay them when you know you can't do that, or you're entering into long-term service contracts where you accept a large upfront payment, or you're buying a bunch of widgets on credit or so forth, and you can't make those payments. Query whether that's an intentional misrepresentation or fraud.
So Kevin, I know you do advise a lot of companies who are in this situation. So either, thinking about companies you have advised, or within the hypothetical of company D, maybe at that point in time, or if you could go back in time, how should and how can board members keep themselves educated, aware, not only of their fiduciary duties, but of these warning signs that might come down the road?
Yeah, I think if the board is functioning well, it should be spotting some of these issues earlier than later. The revenue report and revenue ramp should be clear. If we're not hitting these milestones, there should be early questions and early signs. As you get further into this process and you see that you really do have a problem, I think very regular board meetings, update meetings, maybe monthly, maybe bi-weekly, to understand what's going on. Again, your CFO is critical here. So a really good set of metrics to understand where you are with cash, with other key metrics that you're monitoring, and staying very closely involved, figuring out your alternatives. And there might be several alternatives that you're looking at. One is a fundraising, one is a sale, one is a wind down, and you have to keep all of them moving kind of simultaneously, which is expensive.
For you, I guess, or Tom or David, is there anything about an emerging company, the way their boards are constituted or the way they are run as an emerging company or startup, that might make it difficult for the board members to become aware or take action once they become aware?
You were talking earlier about an example. If not, I have one. Well, I have a client right now who's in exactly that position. Excuse me. They have different types of investors. They came in at different times. They have different equity stakes. But when new money has to come in, someone may get diluted. Someone who doesn't want to participate is going to feel differently about a proposed refinancing or additional capital than someone who's going to be a lead investor. So those are struggles, but and then they can cause paralysis in taking an action, which we'll talk about in a bit.
Yeah, and I'll just add, I mean, it's a really good question. You know, our scenario imagines that we have a venture capital investor. Usually when venture money comes in and strategic money comes in, the board is elevated and you have a lot of people who have a lot of experience on the board. If you're in a company that has only completed the angel round, you may not have that yet. You may have a board that's comprised of the CEO, founder, and people who are experienced business people, but also friends. And maybe that razor eye that you need for making tough decisions isn't quite there yet. So it's a fair point.
One thing we haven't really talked about yet is, given the company hypothetical or other situations, how does a secured creditor kind of change the mix in terms of, I guess, their weight in making the company do maybe what they want to do to protect their interests?
If we could back up a slide, I wanted to mention that we had talked about, you asked about when should the board sit up and take notice and what should they be looking out for. Sherwood advises companies in this situation all the time. We're brought in by the company, by the board sometimes. Very often we're put there because the bank says you're in violation of your covenants. You need to have someone from the outside come in and take a look at this. And so they'll require things such as a 13-week cash flow, an assessment of the business plan, so that the board is forced to confront those things because the bank is holding them accountable.
In an ideal world, when should the board seek the advice of counsel or other professionals?
Well, I would hope that the board is, working closely with counsel at all times. I think as you start to see even one or two of these red flags, that's the time to start thinking about this issue. It doesn't mean that you have to take a drastic action at that point, but as everyone has said, the sooner you engage and start planning for these different options, the better the outcome is likely to be.
Do you find that happens in reality, or do they wait too long?
And I think it varies. It varies quite a bit.
Okay. So at this point, we've gotten to, I think we've talked about these. So at this point, we've gotten to, the company's found out, the warning signs, they're in distress, they need to take some action. And so what are their alternatives? What can they do?
Let me take a crack at this from a headline standpoint, and then I'll ask Tom to elaborate on some of these. The first default step is a Chapter 7 bankruptcy, just a pure liquidation where you throw the keys on the table and essentially can try to walk away. Now, that doesn't solve all the problems, though, because the bankruptcy court is going to appoint a private attorney to act as a trustee, and he's got all sorts of incentives and motivation to try to figure out what happened, and more importantly, try to get some money back for the creditors. And importantly, the trustee isn't paid really materially unless he claws back some assets or sells some assets in one way or the other. So it looks like maybe the quick escape hatch, but it's really not, which we'll talk about. Bankruptcy Chapter 11 is what you more typically think of as a reorganization opportunity and a chance to take a break from your creditors and maybe even lawsuits. But Chapter 11 can be very expensive. It can cost hundreds of thousands of dollars to get into a Chapter 11, and then you need to have preparation to operate under Chapter 11 under different rules. So if there are expensive assets and you've got potential buyers for your assets, that's one thing. If you're pre-revenue and you don't have a lot of physical assets or not sure what the value is of your assets, Chapter 11 can quickly devolve and maybe get converted to a Chapter 7. So very special circumstances are going to allow you to survive in Chapter 11. And then I'll talk very briefly about an assignment for the benefit of creditors. This is one of the alternatives that we wanted to highlight today. This is also a liquidation proceeding. It's very similar to a Chapter 7 in certain ways, but it's not done under federal bankruptcy law. It's done under state law in individual states, and it is not governed by federal bankruptcy law, so you don't typically have a judge involved. You certainly don't have the bankruptcy court, and the rules are a little bit different. But it's also often less expensive, more expeditious, and importantly, the company gets to choose its assignee or its trustee to wind down the company. So we can talk about that in a bit. The next two, just very quickly here, foreclosure and receivership. These are things that happen to a company when they don't take action. If you don't choose a 7 or an 11 or an assignment for the benefit of creditors or some other form of resolving your issues, your secured lender may come and foreclose, just like your mortgage company would come get your house if you didn't pay your mortgage. Or the secured lender could ask the court to appoint a receiver to run the business, and management may get pushed aside or terminated, and someone's in there on behalf of the secured creditors looking out for their interests. So all these things can happen, and we'll talk about in detail in a bit. But Tom does a lot of Chapter 7 work, so why don't you talk some more about the dangers of Chapter 7?
Let me just talk about bankruptcy generally. This applies to Chapter 7 and Chapter 11. So the Bankruptcy Code provides for certain, I guess, strong arm powers that, that a bankruptcy debtor has, which are germane to bankruptcy and are reasons why you would file bankruptcy. For example, in a Chapter 11, if you have somebody who's willing to purchase whatever assets you have, and that's the maximum bid that you can get, and that that purchaser requires an order providing that the sale is free and clear of liens, that's a reason that you would go into bankruptcy. Or if they want to limit successor liability possibilities, they would get a sale order in bankruptcy. In our scenario, if for Company D, if the MSA was not terminated and they wanted to, it was very valuable to the company, they could compel the big box store to continue on with that contract by assuming the contract in bankruptcy. If there's a landlord that's involved that has, there's a long-term remaining on the lease, and that's going to eat up all of the cash, basically, if you breach that, you can cap their claim in bankruptcy. So those are reasons why you would, among others, file bankruptcy. With respect to Chapter 7, comparing it to an ABC, there's different reasons to do it. You have more transparency in a Chapter 7. You have a third party taking over, and it's very public. If you have some ornery creditors or shareholders out there that are suspicious of management, this is a very public way to kind of wind down the company and liquidate the company. So in that sense, the optics are good, and it minimizes some of the distress that shareholders may have. It's again, the public is a double-edged sword. The publicity is a double-edged sword. If you're in an ABC, it's private, so it's, everything is not out there. Publicly, there's public personal information. There's, you have a reputation to uphold. There's stigmas associated with bankruptcy. So those are the reasons why you would look to an ABC. And Dave could probably go into that a little more.
Before we do jump into more about the ABC, because I want to spend some time talking about that, we have another couple, foreclosure and receivership. It could be to Tom or David. Who drives foreclosure or receivership? The choice the company can make.
So again, if the company doesn't find a way to involve its secured creditor and make them believe that they're getting the most efficient results from whatever wind down there's going to be, if the management can make a decision or management walks away, then the bank certainly has the option to foreclose.
Did you guys just?
Foreclose means they're just going to file a UCC Article 9 foreclosure process. It's a very short process. The bank says, we want our collateral. We're going to come and get it. Alternatively, if the bank doesn't want to be quite that aggressive, they can ask a court to appoint a receiver, which, again, just drops somebody in on the bank's behalf. So those are two things that are not company-driven, but could happen if the company doesn't make a decision or a satisfactory decision.
Okay. So, Tom, what is an informal wind down?
Informal wind down is, it's kind of when you know that you're running out of cash, and instead of doing any formal process, such as a dissolution under the Delaware Corporations Code, you negotiate separately with all of your creditors, and you can enter into different agreements with them to settle their claims, and that's one way to wind down.
When might a company want to consider informal wind down versus other options?
Well, it's a lot quicker and it's a lot private, so those are two considerations. But you also need to be realistic, whether it's possible, whether you can reach agreement with the various creditors out there.
Okay, that leaves the other kind of, ABCs and a formal dissolution. I know, Kevin, I've received a lot of, discussions with you in various issues about questions that a lot of boards will have is, do we choose an ABC or do we choose a formal dissolution? I don't know if, Tom, maybe you want to, what is a formal dissolution? What does that entail?
Formal dissolution, I mean, typically it's because most of the companies we deal with are organized under Delaware law. It's pursuant to Section 280 of Delaware Code, Corporations Code, and that's, you follow the process in the code to wind down the company, so you provide notice. It can be 60 days or it can be 3 years, depending on which route you want to go. Provide notice, you collect claims, you need to file different documents to wind down and dissolve the company. When you collect the claims, if there's cash, you pay in accordance with the priorities set forth in the code.
So from either a legal standpoint or a business standpoint for any one of you, why would someone choose an ABC or a formal dissolution? What are some of the considerations the board should think about?
Well, again, I think optics are one thing. In an ABC, you're turning everything over to a third party who's independent, and they're also a professional. They know what situation the company's in, and they can monetize the assets with those considerations in mind. And if you have potential litigation out there or suspicious constituents or whatnot, it's helpful to turn it over to a third party to manage this process.
One thing I would say about a formal dissolution is it can have quite a long tail, Tom, right? Isn't there a board member required to stick around for 3 years or so?
Yeah, it depends on the process, but yeah, that's right. It could last up to 3 years.
So you may or may not have someone willing to do that. In an assignment for the benefit of creditors, all the directors can essentially resign pretty quickly, and there's a fiduciary who takes over all of those matters. And then we haven't really defined what an assignment is. Very, very simply, a company simply hands over all of its assets in trust to a third party. Here's my cash, here's my accounts receivable, here's my intellectual property. I'm going to give it to a third party who acts as a trustee for the creditors, and then the board steps back and resigns generally, and the assignee now has a duty to maximize the value of the assets and then distribute those assets to the creditors. So if you don't have someone who's willing to be on the board, everybody wants to go skip town and go and look at their, continue looking at their more favorable investments. They want to put this behind them and have a party to put a bow on everything. Then that's a strong case for an assignment for the benefit of creditors. Also, the assignee under the assignment takes a lot of the slings and arrows from creditors. We get all the calls. If there are lawsuits, there's a claims process to resolve those. So it does create a bit of protection for officers and directors.
So in looking at these different options, I know we talked about the cost of a Chapter 11, but I think that's a question that I get quite a bit is, what does it cost? What does it cost to do an ABC? What does it cost to do a dissolution or a Chapter 7? What are some of the factors the board should consider in determining kind of the cost of one of these alternatives and to assist them with making a decision?
Yeah, well, I think your point is we've certainly run into clients that can't afford any of these options. So again, getting ahead of this earlier than later, it's certainly, the cost even of an ABC is going to be significant, well over 6 figures, I would think, all in with fees of the trustee, legal fees. I mean, think of it as a mini distressed M&A deal. You're going to be thinking about consents, perhaps, trying to avoid breaches where you can. You're going to be thinking about separating with your employees. You might have to think about WARN Act issues, or in Minnesota, the Mini WARN Act. So there are a lot of things that a corporate lawyer always thinks about when you're doing a sale. They're here, except they're expedited, very fast timeline.
Okay, so Tom, in the context of a Chapter 7, where does a company or a potential debtor, where does the cost accrue to them? Is it pre or post bankruptcy filing?
It's typically pre, so the debtor will would pay kind of for the preparation for the Chapter 7, and then at that point it gets turned over to the Chapter 7 trustee. The Chapter 7 trustee is compensated from the estate, but based on what it can call back into the estate. So Chapter 7 trustee is going to look at whatever's in the estate and see if it can monetize anything. If it can't, it's going to step away and abandon the assets. If it can, it's going to take its time to pursue as much as it can. So might pursue avoidance actions and see what other receivables it can hold back into the estate, because that's where its compensation comes from.
Could also include insurance policies against the Ds and Os, perhaps.
Yep.
So I think we've discussed that when a Chapter 7 is filed, basically the estate is turned over to the Chapter 7 trustee. The pre-bankruptcy Ds and Os don't really have any say in the Chapter 7. But are there non-monetary costs that the board members or company might want to consider during the Chapter 7 process?
Right. So there needs to be a responsible person from the debtor who's going to continue on to some extent to attend the 341 meeting and turn over information to the trustee. The length or duration or extent of that person's obligations are limited and questionable, but that certainly if the Chapter 7 trustee feels that that person's not cooperating, that might raise some red flags. And then directors and officers, as a Chapter 7 is ongoing, one thing that the Chapter 7 trustee will do is look at potential liabilities against the directors and officers. So they need to be wary that they might still be on the hook for personal liabilities.
So David, in the context of an ABC, would do the Ds and Os have those same concerns?
No, not generally. The biggest thing I would say in the difference between the cost of an ABC and the cost of a Chapter 7 is on the other side. A big part of the job of the assignee is to monetize assets. Again, collect the accounts receivable, sell the intellectual property. And we sell a lot of intellectual property at Sherwood: patents, software, know-how, formulas, secret sauce. And a trustee generally is not going to be as good at that as an assignee who specializes in those areas. He might not even get to the file on his desk for several months, but during which time the intellectual property may be deteriorating in value. So when you get to choose the person to wind down and monetize your assets, you can choose carefully and find someone who can maximize that value. And we'll go out to market within days of getting into an assignment process, and we'll know who to target, and we'll have the cooperation almost certainly of the former employees, maybe officers of the company, and make it our mission to monetize those assets pretty quickly. So if you're looking at getting into an insolvency, that's one thing, but if you want overall results and outcome, it's much better to choose someone over whom you have some influence of choosing, and someone who you are able to evaluate, rather than being assigned a random attorney by the court.
So I think we discussed, an ABC is really governed by the state law. Tom, are there particular jurisdictions where ABCs are filed more often, where people kind of want to go?
Right. So typically, I would say they're filed in their state of domicile, but it can also be in the state of incorporation, which oftentimes is Delaware.
Are ABC laws, are they basically consistent across different states, or how do they differ?
They vary fairly widely. There's some that require judicial oversight. There's some that kind of just provide a guidance. The statute provides a guidance. California, for example, doesn't require any judicial oversight, but Delaware does. You file an ABC in the Delaware Chancery Court. Minnesota requires court oversight, and Minnesota, it's fairly new law, and it's fairly stringent in that there's a lot of court oversight. But the flip side of that is it references and incorporates the receivership law, so you can actually get court orders to do some of the things you might not otherwise get in your typical ABC. And then there's states that don't have any guidance whatsoever, and those are just typically it's kind of guided by common law.
Okay, so if we have a company, maybe Company D is, incorporated in Delaware, domiciled in its operations in another state, how would a board consider which jurisdiction to choose to have it say ABC? Or what should they think about?
Well, it depends. I mean, you might want to choose, for example, if you're deciding between California and Delaware, you might want the court's involvement to be kind of a hammer, or to make sure that everybody, there's some transparency or whatnot. in California, you have a lot more flexibility to manage the process yourself, so it really just depends.
I know we've worked with both Kevin and David on different ABCs. What are some of the considerations that you would discuss with the board in terms of where to seek an ABC?
Well, if I had my choice, for example, we might have a company that's operating in California, but is incorporated in the state of Delaware, and then I'd have my choice. I'd have my choice of a California ABC or a Delaware ABC. Generally, I might choose California because the laws are a little bit more flexible. There's generally no judicial oversight, and a little bit less expensive for that reason, and very flexible. On the other hand, I might choose Delaware if I were worried about potential litigation, if I knew that I needed a forum to resolve those issues. I know I have a judge assigned to me already, and I've done that in the past. So we choose between California and Delaware based on those considerations. And there are other states in which we do ABCs, but those are the two states with the best developed law and generally provide the ability for us to do our job. If you're in Minnesota or Washington State and the ABC process is governed more like a receivership, there are some restrictions that make it a little bit more difficult.
I might just point out, too, that filing an ABC can constitute an event of default under loan documents or even under a contract. It could be a breach of a contract. So those are things to keep in mind. And, with respect to an event of default, you probably would want to bring the bank or the lender in for that discussion of what you're going to do. And they might actually drive the decision as to where you end up filing.
From a practical standpoint, the secured lenders cooperation is required to make it go smoothly.
I think, Kevin, we may have touched on this earlier, but it seems a lot of emerging companies, tech companies, startups are going with an ABC instead of either a dissolution or bankruptcy. In your experience, why did they make that choice?
Well, I think the ability that we've heard already to choose your trustee, the speed of the ABC, all seems to be factors that they like quite a bit in the experience I have.
And Dave and Tom, both being based in Palo Alto or near Silicon Valley, is there any particular, reason you guys see for tech companies wanting to go with ABC that might be different from what Kevin just stated?
Well, again, I think unless you are going to have material assets and have good feelings that you're going to sell those assets for millions of dollars, it's just cost prohibitive to do a Chapter 11. And if you go into a Chapter 11 not properly funded, you're likely to be converted to a Chapter 7 and wind up where you don't want to be eventually anyway.
I might just add, and as for emerging companies, you have entrepreneurs who are starting these companies, and they have relationships, and they oftentimes want to preserve those relationships and kind of their reputation as well, because they're going to be founding other companies. And, the ABC process allows that to be a little, more private and less stigma involved.
Good point.
So at this point, I think we have about 10 minutes left. We did want to leave a little bit of a cushion in case people had questions. Unfortunately, people on the webinar cannot ask questions, but if there are any questions from the audience in attendance, we'll take those now. Otherwise, we'll continue with our discussion. Yes, I see a question.
How does the debtor in possession, how does that factor into all of this?
So the question was, how does a DIP or a debtor in possession factor into this? And Tom, do you want to take that question?
Well, debtor in possession essentially is, the debtor after they file the Chapter 11. So when we're talking about the Chapter 11 process, we've been kind of focused on liquidation here when the company's struggling. I mean, you have the option of reorganizing in the Chapter 11, and the debtor in possession gets to manage that process, which is a benefit for filing the Chapter 11. That said, it can also conduct a sale in the Chapter 11 and then, convert the case or liquidate under a Chapter 11 as well.
I think maybe a follow-up to that question, in terms of, in the Chapter 11, the debtor is in possession, they get court approval to operate the company. When might the board not want to do that? Is that a factor they might want to go with an ABC?
Yes, if you're not going to operate the company, you may have a hard time staying in Chapter 11. So that's a good point. Again, an ABC is a liquidation vehicle. But, sir, was your question regarding a debtor in possession financing?
I guess both sides, about if you already got a debtor in Chapter
So Tom's point is, if you're talking about a debtor in possession, that's a Chapter 11 term. Oftentimes, the shorthand is debtor in possession or DIP, DIP financing, and that's when you get a loan from a bank after you have been into the Chapter 11, which allows you, in theory, to operate for a period of time or fund a liquidation process. That financing would become senior to even the secured lender, and I think you need to get the secured lender's consent for that, but it's a way of financing the bankruptcy process, again, if there's reason to believe there's value that can come out the other side.
Got a question there.
Oh, sorry, yes. Who had the question?
All of these different paths, what is the impact of the exculpatory clause in terms of protecting directors, whether it's an ABC or Chapter 7? Does that exculpatory clause in the certificate or the articles have the same protective value?
So let me see if I got the question right. A lot of there may be an exculpatory in corporations, formation documents, and does that have the same effect either in an ABC or a bankruptcy proceeding? I'll turn that over to maybe Tom, Dave, or Kevin to see what happens to the exculpatory clause.
So, great question. Jeff, thank you. So I'm going to have to guess here a little bit, but there are going to be different paths here. If you're talking about the ABC, the corporation continues, the corporation goes until the assets are all assigned. It then has no directors. I would think that up until the point where the assignment occurs, the exculpatory clause is still applicable. So you've got those same protections, and you've got the business judgment rule. You've got all the protections that you would have up until the assignment. Then the board's going to resign anyway, and there wouldn't be claims after the assignment and resignation. In bankruptcy, I don't know how it would work, but maybe you have some thoughts.
To Kevin's point here, it's a couple points. One is you want to make sure that you're covered with the D&O insurance, so that's another consideration that you want to take into mind. You want to make sure that doesn't lapse.
Yeah. And probably a review of the D&O insurance too, which unfortunately sometimes doesn't really get that close scrutiny until these events start to happen. But having an expert with experience reviewing those D&O policies and how it's going to respond is worth knowing, and understanding what the exclusions are, which in a couple of my experiences were broader than the board had expected.
So that goes, I think, into fiduciary duties and an ABC. Is the board protecting itself by filing ABC? Is there any possibility they might be violating fiduciary duties by going to an ABC?
So boards, directors and officers generally have some protections in an ABC process. First of all, by turning the assets over to an independent third party, there's an argument that the the directors have done their fiduciary duty. Secondarily, when it comes time to monetize the assets, it's the assignee that sells the assets. It's the assignee that signs the asset purchase agreement or enters into settlements, not the company, not the officers and directors of the company. So if there is to be blowback from that later, it would fall on the assignee. And that's part of what the assignee gets paid for. So again, as we said a couple of times, the assignment is made, the assets are transferred, and the board generally resigns. And at that point, there's no liability then for future acts because there are no future acts. So there are protections in that way that this is handed off to a theoretically competent professional to execute on the fiduciary duty, take care of the final issues, file final tax returns perhaps, and be a recipient of the slings and arrows later on.
And just to that point, because it's a question that we receive a lot, is the directors and officers, or the directors might ask when they can resign, and you don't want to leave the company in disarray. You want to make sure that it's fairly stable as much as you can get to that point. So handing it off to a third party or somebody who has experience doing that will get you to that place where you can resign.
Question?
This question is for David. What's a typical compensation structure?
How much does Sherwood charge for being an assignee? Structure. That's a better question, is what is the structure of our compensation package? In planning for an ABC, we will put together a budget with the company. The budget will be a predetermined amount consisting of a number of things, but then that's the budget, and that's all the further that we're going to go. Generally, there is little money, if there is sufficient money at all, to fund an ABC budget, and so it's not like we can keep accruing fees. So we'll plan out a budget for an ABC, and the budget will consist of a fee for the assignee to serve in this role. And then, again, all the duties of the assignee we've talked about: monetizing assets, winding down the company, filing final tax returns, making sure the W-2s go out to the employees at the end of the year, vacating a facility, all of those things. So there'll be a fee for the assignee. We store the books and records, by the way, for 7 years as well. So we're on the hook for a lot of work over time. We also hire an attorney in each assignment estate. We have hard costs, such as creditor noticing. We need to reach out to all of the creditors or potential creditors and solicit claims. We run a claims process. We'll, again, hard costs for things like tax returns and 401k. So all of those things will be spelled out in detail in a budget, and it might come to $150,000, $300,000 in a complex case with lots of risk. You don't know what it's going to be, but it's not $15,000 or $20,000. All those things will go into a budget, and then before we will take on the assignment, we'll want to make sure we know how that budget will be funded. Is it with company cash? Will the investors kick some money in? Will the lender perhaps kick some money in because they want us monetizing assets so that they get something back out of it at the end? So it could be several paths to monetize to funding the budget, but it's all planned very carefully in advance.
David, let me ask you a question, that kind of a follow-up on that one too, in terms of the budget. I know, especially in Delaware, that there's a difference between approvals to commence an ABC LLC versus a corporation. Corporation requires a shareholder vote or shareholder resolutions. Is that factored into the budget of the ABC?
Well, Delaware ABCs are a little bit more expensive because there's more attorney fees involved generally. You need to pay things for things such as appraisals and surety bonds, so a little bit more on the expense side. But generally, to get into an ABC, you need board consent and shareholder consent. Now, that can make it difficult for a publicly traded company, for example, to get into an ABC. Rounding up all of the requisite number of shareholders can be tricky, although we've done it. I don't know that Delaware is particularly more challenging in that regard than California, though.
Okay.
But I'll just add, I mean, when you think about in our emerging company practice, that you might have a complicated capital structure with multiple rounds of preferred, each with a class vote, potentially. You hope not, but it's possible. Then getting that shareholder approval can be very difficult when none of those classes have much or anything to gain from the ABC. So it's, when you, as the corporate lawyers thinking about those investment rounds, the voting rights, which we always think about anyway, are important in this context as well.
Okay. I think we're almost out of time. I'm going to see if maybe one last question. If not, we'll take a few moments to wrap up. This question from Mr. Kelly.
Yes, particularly this is for David. Do you ever do going concern sales through an ABC process, or is that always a straight liquidation process?
Good question. The question is, do we ever do a going concern sale through an ABC process? And the answer is, ABC sales are always asset sales, never equity sales. However, you can have a going concern operation and do a sale that way. We do that quite often, actually. Sometimes you go into an ABC and you immediately cease operations and start spinning off assets. But sometimes we run what's called an operating ABC, where we go into the ABC, the assets are transferred, but the assignee will continue to operate the business almost in the normal course for a period of weeks or months. And you do that when you can preserve value. I had a big ABC earlier this year where we did exactly that. We ran a retailer, an online retailer, for 90 days and sold the goods through the website portal just as always. And no one even knew, no, the customers didn't know certainly that there was an insolvency process going on. But that was the most efficient way to sell the product. If we had tried just to dump the product in liquidation, we wouldn't have had nearly the recovery we did. So in that case, we retain employees, we collect receivables, we sell product, we do shipping, all of that. And the idea is just to maximize the value, and it worked out very well in that case.
Existing secured lender, or where did the financing?
That's a good point. Where did the financing for that come from was the question. In that case, there was a secured creditor with whom we worked very closely. And again, before the ABC was initiated, we had everyone's buy-in on a budget. The company had a certain amount of cash. We were given permission to use that cash, and excess cash then was turned over to the secured lender on a regular basis. So we had a lot of cash in that case to run the business on a scaled-down basis, to be sure. But the secured lender allowed us to use the cash collateral because they were the party in interest. They were the ones most going to benefit from an orderly wind down rather than a quick liquidation.
We are just a minute over time. I believe we have to wrap up now. We'll be available afterwards if you have any questions you'd like to come up and ask us. But real quick, we don't have time to really discuss the top 10 takeaways, so I'll turn this to you, Kevin. If you were to have one top 10 takeaway you wanted to point out, which one would it be?
Well, the last one is an easy one, but I would also look at the second bullet.
Be vigilant of warning signs of distress.
Yeah.
All right. Well, thank you, everyone, again. Make sure if you didn't sign the green page, do that, and we appreciate you attending.